In January of 1946, the court decides a case, United States versus Yamashita pronunciation, which is a challenge by Japanese General Yamashita to the U.S. military prosecution as a war criminal that he's being subjected to in Allied-occupied, U.S.-occupied Japan. That case comes to the Supreme Court, and after much agonizing, the court upholds the validity of the process. It doesn't say lack of jurisdiction. It upholds the validity of the process. And it's a 6-2 decision. The two dissenters happen to be Black and Douglas, the people Jackson is least close to on the Supreme Court. Justice Wiley Rutledge is one of the 6, but heartbroken about it and devastated, and really doesn't want to make that mistake again because he's uncomfortable about the procedures that General MacArthur and this procedure in Japan has set up for Yamashita. But that decision happens while Jackson is doing something that is at least arguably similar in Nuremberg. And what does that mean? Well, theoretically, and perhaps literally, it means at least some Supreme Court interest in reviewing, adjudicating, constitutionally scrutinizing Jackson's job at Nuremberg. Now, he's still mid-trial. Nobody's been convicted, so nobody's going to be petitioning, but you can sort of see it coming. And for Jackson, who's still friends, but not best friends with various people, because he doesn't think they play fair, he sees this as a threat that's coming. He thinks it's based in perhaps legal argument, but much more in personal envy and personal pique, and something that he regards as an illegitimate style of behavior in the judicial realm. That's one thing that's coming. A second thing that happens just 3 months later, and perhaps connected, is that the Chief Justice, Harlan Stone, drops dead on the bench of the U.S. Supreme Court. Stone had been elevated by Roosevelt in 41. He was 68 years old at the time. Chief is a hard job. Stone was a heavy guy, and it was a sedentary time, and that was lights out in April of 1946. It's a job that, if Franklin Roosevelt had had another chance to fill, likely would have gone to Robert Jackson. Now, Harry Truman is, of course, the president. It's his job to fill, but among the sitting justices, who's first among equals? Well, by all lights, the one who he's plucked for a special assignment. And so Harry Truman, indeed, reflexively, automatically, and publicly, well, at least on paper in lots of private circumstances, decides to elevate Jackson. Indeed, not to elevate Jackson would be something of, in modern words, a deep dissing of Jackson at Nuremberg by Truman, who sent him there. You're good enough for the world, but you're not the person I'd pick from this vacancy I unexpectedly had. And then what happens is a great Washington, behind-the-scenes, knives-out, ugly, ugly story. And this also may resonate with contemporary events. Jackson is thousands of miles away in a time of very primitive communication, and he's not flying home. He's in the middle of this trial. And anti-Jackson forces, knives out, run this incredibly aggressive campaign, publicly, privately, media, etc., and they change Harry Truman's mind. They persuade Harry Truman that Robert Jackson ain't as great as you think. That indeed, if the Supreme Court is a fractured and uncomfortable place, guess whose fault it is? Robert Jackson is the problem. He's the bad guy. Truman, not wanting to prolong this, it takes him almost 2 months, and not knowing how to sort of parse this, decides, I'm not elevating any of you. I'm going to take my Secretary of Treasury, Fred Vinson, a former circuit judge, and make him the Chief Justice of the United States. And that happens in June of 1946. Stone dies in April, Vinson appointed in June. Jackson's still in Nuremberg. Now, Jackson has, of course, gotten plenty of wind of all this conniving and attacking that's going on. And Jackson then does what I want to highlight as a third Supreme Court-related thing while still at Nuremberg. He publicly defends himself in an unprecedented public telegram from him to the chairs of the Senate and House Judiciary Committees, saying, let me tell you about the Supreme Court. If there's bad behavior in the Supreme Court, let me tell you who it is. It's not me. It's the justices pushing other justices to hand down decisions to help labor unions during ongoing negotiations. It's the justices who in conference stand up and threaten to hit each other in the jaw. It's the justices who decline to recuse themselves from cases being argued by their former law partners with whom they continue to have ongoing financial relationships. In other words, it's Black, Douglas, and to a lesser extent Murphy and Rutledge as part of their cohort. And I just thought you should know. I didn't say this before the president acted because I didn't want to be seen as a special pleader. Fred Vinson is a great man. He'll be a great chief. Thank you for doing that for the country, President Truman. But I've been attacked, and I thought I should defend myself. Now, to give you a counterpart, imagine if John Roberts last week from Malta, where he is teaching a summer course, had walked to a microphone or done a blog post or sent a cable or whatever, blasting his colleagues for saying dirty stuff about him. That would be the counterpart event. I'm glad that Chief Justice Roberts didn't do that. I think it's regrettable that Justice Jackson did it, but there is something sort of noble and stand up for yourself-ish about what Jackson did in 1946. And all of that is part of the context when he returns to the court that fall. Now, what I wish to do in the last segment here is touch on 10 points, 10 cases, if you will, that are part of Jackson's post-Nuremberg service on the Supreme Court. This is the day or two after he has returned and the court has resumed its term in the fall of 1946. You see on the left Hugo Black and Bill Douglas, the clerk of the court, I can't quite see who that is, maybe Harold Burton, and Jackson, yucking it up. There's a popular shallow misunderstanding that this court evermore after Jackson's public attack in June 1946 was a nest of hornets, a polarized place, riven by hatreds, no more friendships. Totally, totally wrong. There were camps, there was sniping behind the scenes, there was some mutual low regard, but there were underneath all of that, and over time, evolving through all of that, continuing collegial functional relationships, indeed friendships. For example, Hugo Black, portrayed as a great Jackson antagonist and somebody who, Jackson loathed and who loathed Jackson from 46 forevermore, becomes again, by 1951, a close, functional colleague and friend of Robert Jackson. Justice Douglas, on the other hand, not quite so much. But I wanted to sort of give you this visual to show you that oversimplifying is oversimplifying. This is worth noting because this is going on while Jackson is back on the Supreme Court. This is Telford Taylor, one of Jackson's deputies in the International Nuremberg trial, who stays and is the chief prosecutor in the 12 subsequent cases that are U.S.-only cases in Nuremberg. So, war crimes prosecution, Nuremberg is a continuing international event and a legal event while Jackson is back on the Supreme Court. And this is the Vinson Court. You see him in the middle. You see Jackson, Tom Clark, Sherman Minton. Those are Truman's 1949 appointees. This is the court that I'm now talking about. Case number 1. Erhard Milch versus United States. The name may ring a bell. He had been Hermann Goering's number 2 in the Luftwaffe. He had testified as a defense witness in the International Nuremberg trial. He had been cross-examined by Robert Jackson, who sort of carved him up very effectively in that trial. And in one of the subsequent proceedings, he was prosecuted by Taylor and convicted. He petitions the U.S. Supreme Court for writ of habeas corpus to adjudicate the illegality of this U.S. tribunal, which has judged him at Nuremberg. The court declines to grant leave to Milch to file this petition, 4-4. This is in the fall of 1947. Where's the ninth justice? That's Robert Jackson, recused, for obvious reasons, from such matters. The 4 tend to be the camp that I've identified, and on the other side, Vinson, Reed, Frankfurter, and Roberts. This case is the start of a flow that, in the end, is about 30 cases of war criminals, both European theater and Pacific theater, petitioning the U.S. Supreme Court to review the legality of the tribunal processes, U.S. and international, that have adjudicated their guilt.